Good afternoon, ladies and gentlemen, and it is a pleasure to welcome our panel of witnesses as we commence our committee study into the jury process in Canada. I'm very glad to welcome Mr. Secand, who's joining us today. Welcome.
Thank you.
And I'm also very glad to welcome Mr. Rankin, who's joining us today, as Mr. Rankin was instrumental in introducing many of us to some of the jurors who first raised this issue and talked about the need that all parties agreed with that this issue should be studied. It's something that is obviously very serious, where people who are serving the public on juries come out of the process feeling that they were not supported by the government in the way that they should be. So we're really glad to hear about each of your individual experiences, and I know that that will guide us going forward in terms of our committee's deliberations. So I would like to welcome today, appearing as individuals, Mr. Mark Ferrand. Welcome, Mr. Ferrand. Mr. Patrick Fleming. Welcome, Mr. Fleming. Ms. Tina Densner. Welcome, Ms. Densner. And Mr. Scott Glue. Welcome, Mr. Glue. And we will be going in the order that the witnesses are sitting in, so we will be starting with Mr. Ferrand. Mr. Ferrand, the floor is yours.
Thank you very much. Thank you to members of this committee for inviting me to speak here today. Thank you to the members for unanimously agreeing to open the study of juror mental health. And if I may also remark on the eloquence and sensitivity that each member expressed during your discussions and vote that brought us here today. Jury duty is one of the most important civic responsibilities expected of Canadian citizens. Indeed, it is likely the last mandatory service remaining since the abolishment of military conscription. However, I think it is fair to say that Canadians have a conflicted relationship with jury duty. Many see it as an inconvenience, a burden, and a major disruption rather than accepting the important responsibility that it is. In January 2014, I was selected as a juror in a first-degree murder trial in Toronto, Ontario. Like a lot of Canadians, I had no experience with the criminal justice system prior to the events of 2014, or had even really been in a courtroom. I served as foreman in the deliberation and ultimately delivered the verdict in court. The trial involved the graphic murder of a young woman, Karina Petracki, by her on-again, off-again boyfriend. She was attacked one morning in the rooming house apartment building they shared. Her throat was cut from ear to ear. She was stabbed 25 times and was ultimately set on fire as her murderer attempted to set fire to the basement unit in a vain attempt to bring the building down in flames. His arson efforts failed, and Karina, mortally wounded, was able to vacate the unit only to die en route to hospital of her massive injuries. The accused also suffered horrible wounds stemming from the fire, suffering burns to 90% of his body, leaving him grossly facially disfigured and disabled due to amputations. He spent 12 months in a medical coma before being charged. In the courtroom, he was a living ghoul, a reminder of the brutality of the attack, and spent many hours staring down jurors in an attempt to intimidate and shock. The trial lasted 4 months and was made complicated by an NCR defense, which is known as not criminally responsible. Hours of testimony from the coroner detailed the graphic murder, including dozens and dozens of autopsy photos of the victim, descriptions of her significant and superficial wounds, articulation of the defense wounds on hands and feet, which suggested the assault was excessively violent and unrelenting. The macabre police video provided a walkthrough of the crime scene, moving about the burned basement unit where the assault took place, moving up the burned stairwell following a trail of blood of the deceased, complete with blood splatters, bloody hand and footprints, and pools of blood up and down the hallway and in the bathroom. Testimony from the fire and emergency response officers on the scene was harrowing and disturbing, especially the testimony of a seasoned fire captain who broke down on the stand, stating that this was the worst thing he'd ever had to endure. The accused was ultimately found guilty of second-degree murder. The accused later hung himself in the Toronto West Detention Centre prior to receiving his sentence. In court as a juror, I took all the evidence in, silently, as was my role. As jurors, we ingest the evidence and the facts. We do not interact with it. We are not afforded an opportunity to look away or raise our hands and say to the courtroom, "Turn that off, I've had enough." I remember when a particularly brutal image was left on our screen during closing arguments for over 45 minutes and wondering why this was even necessary. This image was not in any way going to influence my decision-making. At the time, I understood that any stress or sleeplessness and anxiety was my burden to bear in this particular role as a juror. It's part of the job, I reminded myself. As a juror, you are extremely isolated. You cannot communicate with anyone in any form about the events in court, or even really with other jurors. I would leave the court in a trance and not remembering even how I got home. I would stare blankly into space during meetings at work or at home while my 3-year-old daughter tried desperately to engage with me. My then pregnant wife, who had such an engaged husband during her first pregnancy, now had an emotional zombie in me, unable to communicate or unwilling. I expected these feelings to subside as I left the courthouse on the day the verdict was delivered. Expected to experience a period of reacclimatization as I re-entered my life, and I would be fine. I expected that there would be a thorough discharge and debrief prior to being dismissed, and that perhaps a counselor would be present who could direct us to services, mental exercise, or indeed talk to us. There was nothing. And my feelings didn't subside, they intensified and deepened. After the trial, I cut off communication with all friends and family, only interacting with colleagues at work and then only superficially. I became hypervigilant around my kids, refusing to let them walk alone even a few steps in front of me. I became unable to handle crowds and public spaces. My diet changed. I was unable to look at and prepare raw meat without gagging, which persists to this day. Images would haunt me day after day, an unrelenting bombardment of horror. My daughter's red finger painting would hurtle me back to the scene of the crime, and I would stare transfixed, seemingly out of space and time. Sometimes I would just start to cry for no reason at all. Intimacy with my spouse was impossible, and I found myself either sleeping downstairs on some kind of vigil or sleeping in my children's rooms at the foot of their doors, if I even slept at all. I began to see everything as a potential threat and even began arming myself with knives, just in case, I would say to myself, as I would take my children to the park to play. My daughter asked me one day why I was putting a knife in my jacket, and I struggled to understand even myself why I was doing it, let alone explain it to a 3-year-old. I knew something was horribly, horribly wrong with me. Finally, my family intervened and said that I was ill and I needed to seek help. So the first place I turned to was the courthouse, thinking that they would have immediate access to counselors and services for jurors, as a matter of course. I was surprised when my repeated calls went unanswered, and finally learned that there were no services from the courts available to me unless they'd been issued by a judge. This was the policy in Ontario at the time. Victim services were also not available because, of course, I was not a victim. So began the dizzying fall into the public health system, where it became my responsibility to find a clinician and be put on a waiting list for psychiatric services, which was almost a year long. Finally, almost 6 months, I found a clinic specializing in PTSD, which was my diagnosis, and began paying out of pocket for treatment for cognitive behavioral therapy with a psychologist. Grateful for the treatment, I began thinking that A, I shouldn't have to be looking for counseling, and B, that jurors should receive some treatment after serving in difficult trials as part of their service to the community and the country. Jurors should not have to suffer as a result of their civic duty. I was motivated to do something about it, which began a very long and determined advocacy, resulting in the Ontario government launching the Juror Support Program, a toll-free crisis line and 8 counseling sessions. I wrote to every Attorney General across the country asking them to adopt a similar program or amend the barriers in the existing programs to match Ontario. I was met with resistance or completely ignored in most cases. Yet, I heard from countless jurors from across the country who shared similar experiences and the woeful lack of mental health support in their provinces. Some of those jurors have been ill for many years and remain affected to this day. I was determined to seek a federal standard, which brings us here today. Members of the committee, I want to let you know that treatment works. It's the reason I'm sitting here now and talking to you. It works. I'm living proof of that. Jurors are an important pillar of the justice system. I once said that jurors and first responders are bookends of that system. Jurors close the cases in trial that police and first responders initially answer. We see the same evidence, if not more, and we are all affected by the same horror and tragedy. Yet one group receives treatment and support and the other does not. I hope that you will return a recommendation to the government and the Justice Minister that underscores the critical role jurors play in our justice system and provide them with the support they deserve to return to their lives. Thank you, committee.
Thank you very much. And just before the rest of you speak, and to you, Mark, I just want to thank you for sharing your personal story with us, because I think I know how difficult it is, But I think it's only by us hearing that from yourselves and other jurors that we'll get a full understanding and comprehension of the problem and will allow us to formulate the right solutions. So thank you.
Thank you very much.
Mr. Fleming, the floor is yours.
Good afternoon. Thank you for the opportunity to speak here today. I'm Patrick Fleming, and I served as a juror 3 years ago in a first-degree murder trial that consumed my life for 10 months and beyond. The case R versus Pan involved a young woman, Jennifer Pan, from Markham, Ontario, and 4 accomplices hired to kill Jennifer's parents in their family home. I live with daily thoughts of this crime, graphic coroner photos of bullet holes through flesh, the bloody crime scenes, the chilling testimonies. As the foreman, I can still hear myself and see myself reading the guilty verdict to all of the accused. I can still hear the screams of the family and the friends of the accused in a packed courtroom as I read their verdicts. When my civic duty was done and I was able to go home to my family and return to my normal life, I pulled into my driveway and expected feelings of relief to wash over me. But something was different. I did not feel like I was at my place of peace. Something was not right. This experience made me feel alone. I felt isolated, although I was surrounded by my loved ones. I pulled away from my wife, my family, my friends during and after this trial. I could not put into words what I was going through emotionally. I had many confused feelings, thoughts, and horrific visions during and after this trial. I had to prepare myself to return to my place of work the next day after being away for 10 long months. I knew I was in need of help, but at the time, the courts did not offer any assistance, just a thank you for my civic duty and goodbye. I so desperately needed to talk to a professional, someone who could help me work through my feelings and thoughts. I cannot emphasize enough how strongly I feel that all civilians who are chosen to be a juror should be offered mental health support after their trial has ended. We need assistance getting back to our normal lives. We are civilians that did not choose this path for ourselves, nor are we trained to deal with this type of situation. Being a juror is a monumental job that has had a major impact on my life. I strongly feel that there is a federal responsibility to provide professional assistance to all jurors in all provinces. I still endorse and believe that one should do their civic duty, but one should not pay out of pocket, as I have, to have access to mental health support for doing their part for their country. I would also like to add, I personally know an individual who has used the Ontario Support Program for jurors, and he is very grateful that Ontario offers such a program. It has helped him, his family, tremendously, and he has asked me today to thank the government for providing that health support that he needed. I've also added 2 pages of bullet points that summarizes some of my experiences of stress of jury duty. 1, I felt isolated from my family and friends. I would distance myself. I could not share what I was going through. I had overwhelming feelings of guilt making such a life-altering decision about the defendants' lives. Feeling guilty for not being present for my family emotionally and physically. Feelings of loneliness throughout and after the trial. They are still hard to manage. I had a hard time trying to push down my emotions. I could not feel empathy or sympathy for these victims. I had to be analytical. I only had to deal with the facts of the case, not the emotions. Not the emotions. I accomplished this, but I was left with dealing with my own emotions by myself. Again, I would want to thank the committee for inviting me here today and for all the members of Parliament that have endorsed our advocacy. Thank you.
Thank you very much. Ms. Densner, the floor is yours.
Thank you to the committee for allowing me to appear before you today. I am a first-generation immigrant and extremely proud to be a Canadian citizen. I have the privileges and rights and freedoms this country offers, but with those rights come responsibilities. One of those responsibilities is to participate in helping to bring about justice when summoned to do so. Our right to trial by jury depends on the willingness of all citizens to serve, but doing so should not be at the expense of a juror's own mental health. In 1995, I was the first juror selected to the Paul Bernardo trial. Justice Patrick Lesage advised me the trial would be difficult and there would be graphic material presented as evidence. At that moment, I had no way to fully comprehend how bad it would be. Imagine watching young girls being raped and tortured over and over again. You couldn't close your eyes, you couldn't look away, because it's your duty to watch the evidence. Many days I would go home in a fog, as if heavily medicated. I counted on my husband to care for our children and most household responsibilities, as I often had difficulty focusing on tasks after a day in court. Most nights, the videos would play in my head over and over again. I had difficulty sleeping. Intimacy with my husband became non-existent for a long time, even after the trial ended. I became afraid to go outside after dark, and to this day, that still affects me. I have extreme distrust of strangers. At one point during the trial, Justice Lesage had to call a recess on my behalf as I was having severe palpitations due to stress. Yet I was one of the lucky ones. In his 29 years as a judge, Patrick Lesage only ordered or recommended counseling for jurors on 2 occasions, and the Bernardo trial was one of them. He himself sought counseling after the trial ended. Diagnosed as having PTSD, the counselor advised services were available to me as long as I required them. While time is a great healer, having access to counseling helped me manage the trauma and anxiety and get back to living my life. At the time, I assumed counseling was provided automatically to jurors in traumatic trials. I came to realize this was not the case when I started reading about Mark Ferrant and his mission to ensure all jurors are eligible for post-trial support. If it is our duty as citizens to take part in the jury system, then it must be the duty of the courts and the government to ensure no harm comes to those willing to serve. Thank you kindly for your time today. I hope the committee will make a strong recommendation to the government and Justice Minister that a national standard for jury mental health and counseling is necessary, and that all provinces are required to meet that standard.
Thank you very much. Mr. Glue?
Thank you. Honored members of the committee, thank you for the invitation to speak today as a witness. I'm a 47-year-old male who lives in the GTA. I served as a juror on a second-degree murder trial of a 2.5-year-old boy. The trial was approximately 6 weeks long and included the sequestering of the jury. Forgive me.
Take all the time you need. Don't worry about it.
The case involved the death of a 2.5-year-old boy who was under the care of his mother's boyfriend. According to the pathologist, the boy had sustained several serious injuries, including cracked vertebrae, broken bones, and blunt force trauma to the abdomen. These injuries were sustained in the weeks leading up to the boy's death. The reason I know this is because I had to sit through an extensive autopsy report, graphic images of the crime scene, and how they determined throughout the investigative process, specifically the autopsy process. Thank you, sir. The accused was convicted. No, sorry, let me go back in. The trial hit home for me, as at the time of the trial, I had a 2.5-year-old boy at home. The thought that somebody could do this to oppress a child obviously still disturbs me. The accused was convicted, and to this day I can still hear the cries of the courtroom, the victim's grandfather in tears, reaching over the pews, crying, "Thank you, thank you." The courtroom security abruptly ushered us, the jurors, away from the courtroom, then snuck us out the back tunnel of the courthouse. This was done for our own safety, as a riot had broken out in front of the courthouse, as members of the convicted's family and the victim's family clashed. I found out about this after I got home and saw it on the news. Returning to work was difficult. The empathy was, my employer was not very sympathetic to me being away for 6 weeks, even though I went to work before and after the trial, as well as on weekends to try and keep up. It was budget time and everything was due immediately. The culture of this employer was that financial deadlines and commitments were paramount in over any other work that had to be done. My first day back was a fog. It was very strange to me that one day I'm sequestered away from my normal life and family, deciding the fate of an individual, attempting to attain justice, and the next day being in a boardroom meeting about a new computer software program that my employer was implementing. Within days of the trial, I knew I needed support from a mental health professional. I sought out an EAP program counselor. She was tremendous. I was fortunate that my employer offered such a program. The fallout from the trial ultimately led me to leave my employer. The treatment I received, the lack of understanding from my superiors, peers, and upper management made me feel that I had done something wrong, like I was on vacation or something, not living up to my job requirements. I was lucky to have the support of an EAP program and a great counselor. In time, I came to the realization that I needed to move on from this employer. Personally, the counseling led me down some paths of my own life that I would not have explored without it. These were positive changes and awakenings to my own behavior. To this day, I worry all the time that something will happen to my kids, that someone in their life will hurt them, that the way the victim was hurt. I am super vigilant, accused of being way too overprotective, but knowing what I know, I cannot be too careful with who looks after my kids. I would do my civic duty again. I believe that the justice system in Canada is truly one of the best in the world. I witnessed firsthand the rights of the accused, the judge's constant assurance the accused received a fair and unbiased trial. Even the best judicial system in the world can be improved upon. Making post-trial support available for all jurors who need it would close the loop on the jury trial system. Having an extended period of time after the trial to normalize before returning to work would greatly help as well. Creating a robust education package for employers and potentially co-workers of jurors may help as well. Having separate parking areas, break areas away from the lawyers, families, and participants in the trial would also help. I would like to re-emphasize and encourage that you make post-trial support standard nationwide to provide help to those who need it, those who are the backbone of the jury system. It would certainly make it much easier for them to cope with the outcomes, facts, images they endure to perform their civic duty. Thank you for your time. I am honored to have participated in this process. I apologize for the emotions.
Thank you very much, and I think the emotions are an important part of why we're here today, because again, it's only when we hear truly what you've gone through that it enables us to, in our own heads, feel like we understand the experience. So thank you. So now we're going to go to questions. We'll do one official round and then take questions from everybody, okay? So we'll start with the Conservatives, Mr. Nicholson or Mr. Cooper.
Thank you very much. I've been a member of this committee here for the last couple of years, been involved with Justice and the Justice Committee here for close to 20 years of my political career. This is one of the most moving testimonies that I have heard in my career. And I want you to know this, that I truly believe that your testimony and what you have doing here today is and will make a difference. Mr. Glue, you said that we have the best judicial system in the world, but it can be improved, and this is a gap in the judicial system that definitely needs to be improved at all different levels. And one of the reasons why I've been so interested in doing this is because we can contribute to what you have done, Mr. Ferrand, and those working with you on this, because you have identified something that I don't really remember being identified specifically. And having your firsthand experience and the firsthand experience of all of you will be invaluable. Mr. Ferrand, you said that you wrote to the Ontario government and then they came up with this program here to provide some assistance. You said you wrote to other attorneys general other attorneys general and or governments across this country. Some of them replied to you, others you didn't. I wonder, I'll leave this with you. I don't want to put any pressure on you, but it would be interesting for us to know if you could tell us give us copies of what they did say to you here, because we now want to be involved with this business, and I'd be very interested to hear what those different provinces or territories had to say to yours, or if in fact they said nothing at all, because again, this underscores how the challenges that we have on this. Do you have any comment on that?
Yeah, no, I'd be happy to share any and all of the correspondence that I've had with those attorney generals and ministries that responded to me. So some of the responses were, well, you know, we just haven't heard from any jurors who've complained, so I just don't think we have a problem in this province. And you know, I heard from jurors within that province who said, I've been on a horrible trial. I've experienced no support, and that was 10 years ago. So I've heard from provinces say, well, this is going to be costly, and we're concerned about the undue financial burden to the taxpayer that this program might incur. And I would always say, well, it's not about the cost of the program; it's the cost of you know, the lives that we save as a result of a program being put in place. Prior to the program being introduced in Ontario, a juror in London, Ontario, took her life after a case involving the homicide of a child went to mistrial. And I'm certain that if a program had been in place prior to that event, that person might have been saved.
When you got a letter back from one of the attorneys general talking about the possible cost, was there any mention in that letter of the cost that jurors have to absorb?
No,
was there any mention of that?
Nope, there was no mention of that at all.
Would you agree with me that part of the neglect of the interests of jurors is also enumerated, so to speak, in the lack of any sort of compensation that we give to our jurors, that you go for a couple of weeks with zero, and then the message they send to you afterwards, here's $40 a day. I mean, I would believe that, and people like yourselves made it very clear that you do this out of your physical, or your public duty to serve, but don't you feel you're getting the wrong message when the government tells you here, you can be here for 2 weeks, good luck to you, your employer doesn't have to pay you, and you'll get nothing, and then $40 a day after that?
There's so obviously in the province of Ontario, there's the employer is not obligated to pay for your time away from work. They're obligated to maintain your job, but we've heard from jurors where, and I'm one of them, where the employer feels incredibly put out, and there's a lot of pressure on you as a juror to continue to work on top of doing that civic duty. So I was one of those individuals who went back to work at the end of the day after seeing horrific evidence, going back to the office, meeting with my team, then working for 6 hours, and then going back into the courtroom the very next day and carrying that on. Because, while my employers, gradually understood that I was going through something pretty harsh, the bottom line was, you're going to get the job done right, meaning the job that I was being employed for. Jury pay, doesn't really cover the costs of transportation and incidentals that a juror has to fulfill within a day of jury duty. If you think about if you're commuting from Pickering to the downtown Toronto courthouse and parking your car, that's absorbed. It's gone, let alone trying to eat something. So
even a message there, and one of the criteria for compensation, they made it very clear that they won't provide anything for child care expenses here, and I guess there's a certain message that's being sent out there. I wonder, if the short time I have, if the other three have any comment with respect to the questions I directed at Mr. Ferrand. Any comment?
Just maybe that you can see how much trouble the courts are having in actually getting jurors to want to participate.
Right on.
Because not only does it take them away from their normal everyday life, But yes, there is no compensation for doing that, and we do it out of our civic duty.
Fleming?
I have to say, I work in a place where many people are around me, a lot of employees. And when they get that summons, the first thing they do, because they know I've gone through this ordeal, is that they come up to me and ask me, how can I get out of this? How can I get out of this? That's the first thing they say every time. And I have to tell you, I tell them, like, why do you want to? Because I still endorse it. And they know what I've been through. And I tell them, this is important. This is important for all Canadians to do. Because I tell them, you know, like, if you're in trouble yourself, when you want your peers to overlook it, and they just look at me like I'm nuts. No, you're laughing, but it's honestly, that's the very first thing they say is, how can I get out of this? And you know what? We can change that attitude. I really think we could change this attitude. And with a little bit of, with the government's help, maybe we can reform the jury altogether, you know, maybe put up the wages a little bit. Make sure that the juror knows that there's support there for them, because that's part of the problem. First thing they worry about is their family, financially. You know, why don't we make it a little bit better for them? Let them know that we'll help you pay for daycare, right? Give them a little bit more money. You know, long cases maybe say we'll give you a break, like a little vacation halfway through it. You know, let's make it a little bit better for us, the private individuals out here, because we really do love our country. And you know what? We support our country. Our country just needs to support us. That's all we're asking for.
Well, you've made a difference here today. I can tell you that. I truly believe that.
Mr.
We
Blue,
are
did you
here
wanna-
to make a difference. And with all the support here, maybe we can make the difference.
Mr. Clue, did you want to add anything?
The only thing I would say is an education package to let people know what being a juror is. A lot of people don't even know what that process is, what that looks like. As Patrick said, when you go to the courthouse and go through the first step of the process, you don't know what's coming next. There's no kind of manuscript or direction of where you're going next, who you're going to be talking to, etc. I've had neighbors come up to me afterwards and same thing about, how do I get out of it? How, you know, what did you go through? And just to reiterate to them, relax, it's okay, it's a good process to go through. They'll walk you through it, and if you're chosen, then you're expected to do your civic duty.
Thank you very much. Mr. Fraser?
Mr. McKinnon's.
Mr. McKinnon's going to go for it? Okay, sure. Mr. McKinnon?
Thank you, Chair. Thank you all for sharing your experiences with us today. Your words are powerful and important, and I doubt that through words we'll ever be able to fully grasp what you've gone through. And I thank you for your service. So studies have shown that jurors experience different stages of stress during different stages of the trial. So perhaps when you're summoned, during the trial, at various junctures through the trial, and afterwards, is there any one point where you think we need to give the most attention? And I guess whoever would like to answer, please.
Definitely when the trial ends, people need to figure out a way to get over the anxiety of the trial and the stress and the trauma of it. But during the trial, when you go home every day, you're told you may speak to no one about this. And so you can't speak to your husband about what happened. So you can't even describe how you feel, because in that way you might have to disclose something that you're not allowed to disclose. So if there in any way where a court-appointed psychological counselor, that maybe when people, if you know, maybe for me it's day 10, but for somebody else it's day 5, at the end of the day I can go and say, you know, this is a particularly hard day today. The evidence was very gruesome. Before I go home, could I talk to you a little while and tell you how I feel, and how do I not take this home with me?
Okay.
At the end of the trial, it was so abrupt. It was like 1 minute I was reading a guilty verdict to 5 individuals, putting them away for 25 plus another 25. And then the very next minute, the court doors open, and I'm going home. Think about that.
It did end with an abrupt stop. It was rather shocking that there was no debrief. There was no sort of standardization of dismissal. It just seemed to be incredibly abrupt and convoluted. Like literally, pack your bags and off you go. Our trial was a little bit unusual in the sense that the justice came to our jury room and had a cup of tea with us. But that's very, very unusual. And even then, that wasn't a dismissal. That was just you all went through a really long trial, and I just want to say thanks. And it was a handshake. That didn't help me. But we've heard from a lot of people who've just said you literally the rug is pulled out from underneath you, and you're walking out of one very tight vacuum into another. And you're in this zombie-like state, just lost, because you're suddenly, back in the world. You're back in the world out of having been through this. It feels like Tina said it earlier today, it's like a plane crash. You've gone through this thing that you can't explain to somebody else, but you feel like you have to.
So what I'm hearing here is there's really a need for ongoing counseling during the trial that is accessible to jurors on request, perhaps post-trial follow-up, debrief, and to evaluate the circumstances, to perhaps see if further counseling is needed, and then, of course, counseling to carry on beyond that. Would that pretty much cover what you think we need?
During the trial, I mean, I think I think certainly post-trial is where it is most necessary, and for some people, the intensity and the crisis occurs much later. Like for me, it deepened, and like a lot of people, I just decided to bury myself in work and bury myself in a distraction that would allow it to go away, and it would just disappear. I hoped it would just ebb, and it didn't. I followed the worst personal advice, and it intensified. And unfortunately, when I looked for an apparatus, there was nothing there.
I'm wondering if having someone to talk to during the trial would tend to smooth out the transition, to relieve the pressure, perhaps on an ongoing basis. So perhaps the end of the trial and the ongoing stress would not be so great in the first place. Is that a fair guess?
I agree with that, especially in my case. I think for me, I mean, there were days where it was just overwhelmingly traumatic, especially on the days where there was video evidence, because they played it over and over and over again. And so maybe at the end of that day, if I had the opportunity to speak to someone, the end result may not have been so bad. I can't say that for sure, but I just feel that maybe it would have alleviated some of what happened at the end.
I believe that during the trial would be a great asset as well. Dealing with the prosecutors as they go through the process, they want you to relate to the victim. They want to build that victim's personality. You see the videos, you see who they are in their real life, and then wham, here's the evidence, here's the other stuff. So as you said, on that day when you get that wham, certainly would be helpful to have somebody to talk to and debrief or normalize it or try and digest it in some way.
Because you can't talk even amongst the other jurors about anything, right?
I think the judge might be able to make that call, though, too, because the judge is watching us as the jurors, and I think he can recognize when he needs to pull a short day as well, and maybe that's the time to do it, because the defendant and the prosecutor, like, they stick these graphic photos, videos, and testimonies in front of us, and they know they're disturbing us. They know it. It's part of their game sometimes.
Thank you. Mr. McGregor.
Thank you, Chair, and thank you to each of you for having the courage to come to Ottawa today to share your story. Like Mr. Nicholson said, I think everyone around this table right now is just in awe of what you've gone through and what you've had to suffer through just for simply doing your civic duty. And none of you are professionals in the justice system like every juror across this country. You're ordinary Canadians plucked out of your ordinary lives and called to do something extraordinary, and you've had to go through a lot. So I really want to start off by recognizing that, and I truly hope that what we hear today and as this study continues leads us to a place where we make those firm recommendations, those much needed recommendations. And so I just wanted to again thank you. Now, speaking of recommendations, that's ultimately where we want this report to end up, making recommendations to the Minister of Justice. And yes, we realize that under our Constitution, the administration of justice does fall under provincial jurisdiction, but we should note that we as federal legislators are responsible for drafting amendments to the criminal code, that very same criminal code which contains section 627, which allows judges to provide supports to disabled jurors. We are responsible for the federal penitentiaries where the offenders who receive guilty verdicts in these gruesome trials often end up. And we just completed a study trying to find avenues where the federal government can try to impose some sort of a national standard on access to justice, particularly through legal aid. Now, all of you have testified about the need for strong national standards, and in the interest of arriving at a clear recommendation, I was wondering if each of you could just take some time as to some of the ideas on what you think that could eventually be and look like. And I'll start with you, Mr. Ferrand, please.
I've heard from so many jurors, former jurors across the country, and who've had to sort of look over the proverbial fence at the province next to them, which has a program for post-trial support, and they're sitting in their own home province, and they're saying, well, how come that province, they have access to post-trial care, and in this province, there's nothing. And I've been through a triple homicide. I can't leave my house. I can't look my husband in the face. I can't go to work. I can't even play with my kids. And I'm devastated. And I've heard that too many times. And I think a national standard and a strong one that doesn't set limits on the amount of counseling that's available to the individual, that says it's a covenant between the clinician and the juror, the patient, that determines the length of counseling required to get that person back to. I mean, I have PTSD. It's my new normal. It's what I am now. I don't beat myself up about it anymore, but it's just going to be a part of me. I'm not able to do the things that I used to be able to do. I'm not able to go out in public the same way I used to before this. So again, it's not to, in some cases it's not to return to your lives, but it allows you to keep moving forward. So, is the Ontario program the baseline for this? Is 8 counseling sessions enough for an individual? I was barely able to articulate what was wrong with me in 8 sessions, let alone begin to develop coping mechanisms to move forward. So I'm well past 8 sessions. But I think it's incumbent on us to create a program that is universal for all Canadians serving in a jury, no matter where you live in this country.
Thank you. Mr. Fleming.
I feel like across every province and territory, we should all be equal. We as jurors, no matter which side of the province or country we live in, we're providing the same service. We should actually have the same amount of access to mental health support for everybody across our country. And not everybody will use it because every individual is different. So some might need 8 weeks, one or two might need 4 weeks, some might not need any. But we need a standard of, we need to draw the line somewhere and make a standard and start from that point. And then we can fine tune it from there, I believe. But for now, I think we need it equal across the country because we're all doing the same job no matter where we live.
I'm fairly sure that court staff, like court reporters, interpreters, receive access to counseling because they sit in those courtrooms every day. So maybe it is that that same person that is available to them becomes available to jurors at the end of the day if they feel need to or go back. And like Patrick said, some people can walk away from a trial and go, okay, we're good, I'm good. And some people may not be able to survive without having counseling. And so I don't think it has to be mandated, but I think it needs to be offered. And so that at the end of a trial that is particularly gruesome, if the courts can say, you know, this is available to you, please feel free. Because some people, like these gentlemen, were all employed. I was not employed. I was a stay-at-home mom. So as a stay-at-home mom or a senior citizen, I don't have access to company benefits. So this comes out of my own pocket if I wasn't offered it through the court system. So how do those people, do you go, gosh, I can't afford to go and see a counselor that charges me $300 an hour 20 times. So I think it just does, you know, if as citizens we are doing our duty, I think the country in turn has to do its duty to provide for us.
Mr. Glue.
I'd like to echo those of the other witnesses as well, just equality across all the provinces. I was lucky enough to be employed by an employer who had the benefits of the AP program, and it worked out tremendously for me. So I would even say coordinating those benefits that are already available to those who are lucky enough to have it with those ones that would be prescribed by the legislation that you maybe be proposing, or the recommendations coming out of this would certainly help as well, and maybe lighten the burden a little bit financially, et cetera. But that's about it.
Thank you. Thank you very much. Sorry about that. Mr. Fraser.
Thank you very much, Mr. Chair. Thank you all for being here today and sharing your stories. Your testimony was very compelling, and I think it's left an impression on all of us around this table, and we certainly appreciate all you've done, not only in your jury duty service, but taking the time to prepare for this, to come and give thoughtful suggestions about how we can improve this for other people who will be jurors in the future. And I think it's a testament to your feelings for our country, not only to have gone through the jury duty service and taken it seriously, but to have taken the time to come here, and I appreciate that. I know in Nova Scotia, where I'm from, there are instances where people have not shown up for jury duty, and the courts have made comment on that, about it being an extremely important part of our judicial system, and we need to make sure that we're there as governments to support jurors, to know that they have the support, so that when they're doing the honorable thing and doing their civic duty, that we'll have their back. And so I hope out of this will be constructive recommendations based on your testimony and those witnesses who will follow. Mr. Farron, if I could start with you. It was touched on a moment ago about the fact that there may be some cases that will more likely result in the need for support for jurors than others, so particularly gruesome cases, some of which you have described here today. Do you have any suggestions as to how the courts would differentiate between certain cases, and would there be any benefit in having certain cases where there would be a mandatory check-in with the jurors on the way out, almost like a post-jury interview, so to speak, to ensure that they're not only aware of all of the services, but aware that if they do have problems in the future, that there are supports that they can come back and utilize in the future.
I think amending and improving the discharge process is necessary, and I can only really speak to the one in Ontario, or the one that I experienced myself, which was a non-discharge. Really, I was just, aside from sharing a cup of tea with the justice, we left the courthouse really abruptly. So I was shocked at the fact that there wasn't any formal debrief. I was, as I was delivering the verdict in court and getting ready to exit, I was expecting there to be this very structured judicial type discharge, very formal in terms of even in terms of like what's expected of you now, sort of like, so you've been a juror, now this is what is expected, in terms of even how, if you're contacted by the media, if somebody asks you about the case, any of those things, there's just nothing. So to your question about a post-trial follow-up or some sort of interview with each of the jurors, I mean, I think giving them access to and an understanding of what's expected of them, what they've gone through, a sort of decompression period will help a great deal. And again, having a program or someone to talk to when you need it, at no expense, and taking some of that burden away would be incredibly valuable. Pre-trial, you don't have that opportunity. So and I think that's part of why the system is as it is that you don't want to opinionate a juror by saying that this trial will contain graphic evidence, will contain subject matter that is going to be deeply disturbing, because again, we don't want jurors to be prejudiced to form an opinion and an emotional response to the evidence that they're going to see. The evidence has to speak for itself, and the trial has to unravel as it will. So that's the burden of the juror. That's just part of the job, and I think that's not going to go away, and I don't expect that we can change that.
No, I think that's a good observation. With regard to Section 649 of the Criminal Code, that basically is the jury secrecy rule, where you're not allowed to discuss deliberations with anyone. Do any of you have any thought on how that could impose a difficult challenge on somebody who's gone through this in talking to a mental health professional after the fact? Do you have any comment on that?
It's incredibly, that component is incredibly difficult. I've never spoken about it to anybody, and I never will. That's going to go to my grave. So having somebody who is, I guess for the lack of a better term, bonded, and if it's possible to have an avenue to talk about some of the difficulties in that case without violating the statutes of the code with respect to deliberation and the like, might be incredibly helpful. Some jurors, the stress and ill health that they have felt has come from, imagine going through an 18-month trial and being deadlocked and not being able to deliver a verdict, and it going and the case concluding there. So the cries from victims' families in the courtroom, the outrage, the guilt, the enormous guilt that individual feels, knowing that it's the facts that was not able to deliver a verdict. It's not the jurors that weren't able to do it. It's the facts in the case that weren't sufficient to deliver a verdict. That's the issue. But it doesn't matter. The individual feels that, and they carry that guilt and that sense of shame with them for the rest of their lives. And again, they can't talk about it.
Any of any others have any comment on that, about an exclusion perhaps for a mental health professional to discuss these items that were
I think it
part of
would
that
be.
deliberation?
Sorry to interrupt you. I think it would be maybe a good idea. I know being behind closed doors with 11 other people that you might not choose to be around, and you're behind the closed doors and you're trying to do your civic duty, and it can be difficult back there. And sometimes, and I've heard that the most stress of a case has been being behind those doors, and you can't talk about it. And we take this job, this civic duty, very seriously, and we don't let that out. But maybe there's a need to do that. I'm not sure.
Ms. Dancer, just briefly, did you have a comment on that?
I agree. I mean, after the Bernardo trial ended, I was only sequestered for one evening, and basically I got the question, what took you so long? And you can't answer that. You can't discuss what the other people in the room would like to do or not like to do. And so if there is a court-appointed psychologist that is already sworn to confidentiality, then that would certainly be able to alleviate some of that pressure. And again, you know, you've seen the evidence and you've decided that that person is guilty, but as Patrick said, you are still sending that person to federal prison for the rest of their life, and you shouldn't feel guilty, but somewhere deep down you still do. And so talking through those things could be quite helpful.
Thank you very much. Now we're going to go to a free round of questions where we'll just take questions that people have. So I just want to see, Mr. Lightbert, you'll go first, and Mr. Secan, Mr. McGregor, and back to Mr. Fraser, and then we'll see what happens after that. So, Mr. Lightbert.
Thank you, Chair, and thank you all for being here. I'm not going to repeat what everyone has said, but I certainly concur with what's been said. I would also say that it seems like everything that you have recommended today is so obvious that I can't believe that our court systems haven't been doing this prior to this. So in politics sometimes you kind of wonder how has this gone on so long that somebody hasn't done something about it. So thank you for coming forward to make the recommendations. I want to sort of, I think that we've really covered a lot of what you're here for, but I'd like to maybe explore something a little bit different. But again, maybe there's a need for this. So, Ms. Dancer, you mentioned about the court clerks and the staff that have to go through this on a daily basis. I know someone who actually was a court clerk and ended up quitting the job not because of what you said, but because he got so angry at how things were I guess, in this particular instance, people getting off when they shouldn't have gotten off, that sort of stuff. As a juror, is there an anger that builds up? I mean, it's human that I hear things or I see things on the news and it makes me angry. Is there an anger that builds up being a juror that you kind of take away with you and it's kind of down there for the rest of your life? Is that something else that needs to be kind of dealt with?
Oh, certainly. Ms. Homolka is living a very wonderful life. That was pretty hard to swallow and made everybody there angry. And so you build this, and because of course she was part of the testimony of this trial, and you go, and again, it's very hard to understand. We're not lawyers. We're not a part of the justice system. We're just ordinary, citizens. We don't understand how the justice system works and why did she get this deal and why is she walking scot-free after 12 years. And these things are very bittering to us as citizens. And so, again, having somebody maybe help you with those issues could be helpful. But I could understand certainly the clerk who has to see it over and over again would be traumatic.
Anybody else?
Maybe that anger could manifest while behind closed doors. Jurors' code of conduct isn't always the best, and if it's not spoken, it's not seen.
The bittering, I think, comes from, again, some of those individuals who have gone through a lengthy, complicated, brutal court case that in the end is deadlocked. And so that's a terribly difficult pill to swallow. And those individuals, and I've spoken to many of them, are very damaged, different people as a result of that, and the manner that they interact with society has changed. They sort of said, you know, like, why am I even bothering anymore? They lose touch with you know, faith in government and apparatus and the like, and it's completely understandable, and it's not their fault.
Thank you.
I
Thank
don't.
you, Mr. Goose?
Yeah, if I could. I just personally, I don't have the anger. I think I'm just more sensitive to things that are going on around me in certain areas. Kind of a big burly guy that's kind of a teddy bear inside. So that even has gone, you know, kind of further down the road of that. And able to talk to people in regular life, and they don't know what I'm carrying around. They don't know kind of my bag of tricks that's in over my shoulder. To deal with that, just going out to play hockey, etc. Nobody knows, and it's kind of nice to be able to not have to deal with that in one sense, and it's kind of an escapism, and then the other sense, I'm just very well aware, especially with children being what I was through, of what potentially could happen out there. So just carrying that with me all the time is sometimes tough. Thank you. Thank you, Chair.
Thank you very much. Mr. Sikand?
Thank you, Mr. Chair. I too would like to start by acknowledging and thanking you for your sense of duty and the belief in the civic system. This was very disturbing to hear, so I can't even imagine what it would be like to be in those rooms. Having said that, I'd also like to say if any of my questions come across as deprecating or diminishing, they're not meant to be. I just want to extract as much information as I possibly can. So I'm going to start with Mr. Glue. You were talking about a pamphlet or an education package that would be beneficial during the vetting process. Could you speak to that a bit about how we could figure out whether some people would be better fit to serve knowing what they're about to see? So I'm coming at the question basically because you said you had a 2-year-old son as well, and maybe if that was something that could have been acknowledged and taken into account, maybe you wouldn't have been chosen for that trial. How beneficial would a compatibility package or program be at the beginning?
So personally, I believe it actually worked out very well that I was on that being chosen, because I could relate to it very, very closely. I was speaking more about from the education package of maybe what it is to be a juror, what the expectations of the juror is, and what the expectation of their employer or their coworkers or et cetera would be moving forward with it. We get, as we were going through the process, we got a kind of a hokey video that we were shown about what a juror is and what their duties are. It was classic 1970s movie filming, et cetera, updated to the modern, social media, et cetera. Even an education campaign or an advertising campaign about what it means to do your civic duty as a juror would be something beneficial.
and I'm glad you mentioned that you were able to relate, because I think, Mark, you were saying that you need to have an authentic emotional response in order to actually carry out the duties as well. So it wouldn't necessarily be beneficial to the system to exclude people. So can you speak to what Scott just said? How can we make it at the vetting process that you're fit to serve, so you're not excluded because you might be sensitive to some of the issues, but at the same time, really find those that might be susceptible. You know what I'm trying to ask here?
I mean, jurors are I guess, pre-screened. So I can only speak to the province of Ontario, but the potential pool is issued a questionnaire in advance that all citizens are expected to fill out and return. There are a series of questions on there about reasons that you might be excluded or exempt from this trial. One of them is having an existing health condition or mental illness that would prevent you from serving on that trial. And for all intents and purposes now, I would be exempt from future jury service because I have post-traumatic stress disorder, and I would have to disclose it legally not saying that I would want to exclude myself from jury duty, but I would have to disclose that. But I think the more, in my opinion, is the more screening potentially that we put into pre-screen potential jurors, there might be a potential to also maybe screen out people who would be appropriate jurors. I wouldn't want to put limits on the ability to have a fair trial by putting in more and more confounders to limit citizens from the potential. So I'm before this trial, and I still today, I'm a fairly able-bodied person. You bring into the courtroom all of the collected experiences that an individual has in their life. I didn't think that a trial of this kind would impact me, but it did. I would never have said it, prior to being in the courtroom that I would be impacted by it. But I was.
Thank you for that. I'm going to continue by asking you about, so you mentioned that they left up a picture for 45 minutes, and you don't think that was vital to maybe fully grasp what was going on or some kind of information? It was just up there for the sake of being up there?
So I was in what is called a state-of-the-art courtroom. In that case, there are computer screens, sort of large-scale monitors in front of each of the jurors. There are two very large television screens facing the public gallery, and another one facing the court. So most of the evidence that you're seeing in the trial is displayed to you in that monitor in front of you. So it was during it was during the Crown's closing argument that an autopsy image was purposely displayed on that screen. And again, by that point, I kept thinking to myself, why is that image necessary now? Because it's not going to suddenly be part of my decision-making apparatus as an individual. It's not going to change or create a new opinion for me. I'm not suddenly going to be swayed by this. But you couldn't look away from it. So you couldn't find a place in the room where you could place your eyes to at least hear the summation of the individual delivering the closing argument. And all of the jury, and you could feel the sort of energy coming from them around you, were shifting in their seats and feeling the same level of revulsion. And again, reflecting, this wasn't necessary. This is just some kind of showmanship.
So sorry, we're going to go to Mr. McGregor because now you're over 6 minutes. Mr. McGregor.
Thank you, Chair. one of the privileges of being a member of Parliament is that, in my short tenure so far, I've had the opportunity to meet with many first responders and the men and women who serve in our armed forces. And as you know, within all the ranks of the first responders within our armed forces, great strides have been made over the last several decades in the recognition of PTSD, or what they like to now call operational stress injuries. When I speak to members, whether they work in the ambulance service, the fire service, the police, they now recognize that the early detection of PTSD and the early treatment is so necessary to stop the cascading problems that can happen later on, because really this is about an investment in a valuable member of their crew. It's an investment in a valuable employee who has an incredible skill set, who puts his or her life on the line to help ordinary Canadians. And in light of that, they recognize that if they don't do those investments first and foremost at an early stage, the costs later on, whether it's in a broken marriage, acting out at work, the cost to society later on can be quite tremendous in some cases. And so in light of those facts, that these first responders who by the way volunteer to do their jobs, they willingly entered their service, in light of that fact, and in light of the fact of the incredibly important role that juries and jurors serve, I mean, would you not agree that the state has an incredible obligation in regards to supporting you should you need it, and that to those who may argue that it's a cost issue and quibbling over the cost of this, I mean, would you not agree with me that this is really an investment in you for your service, so that when you return to society, the later on costs, whether it be in a failed relationship, the costs that you have to deal with personally, I mean, would you not agree that we have an obligation here? This is our acknowledgement of the service you've been dragooned into. And I just would like to hear from each of you, because I strongly feel that we need as much testimony from you as possible when we're reflecting back on this to make our recommendations. You occupy this unique spot in our society of having experienced something that no one around this table has experienced. And so I would like to, again, just hear each of your thoughts on that particular point, the obligation the state has to you individually for your service.
I don't want what happened to me to happen to somebody else, in the sense of having to go through serving my civic duty as a juror and not having the adequate support post-trial to allow me to come to terms with the imagery and experience that I went through, and not be able to return to your life and with a sense of normalcy. So I had to I fell into a dizzying well, looking for some kind of support after the trial was over, and all the while that I was ferreting out psychologists and like interviewing them and finding out, well, I'm not really qualified. I don't think I can really help you. On to the next one, getting a list of psychologists and really going down that list and thinking to myself, why am I doing this? Why am I doing this? This isn't right. And then the sickening sensation that I had once I started to understand that this was not this hadn't just happened to me, it had happened to many people, and it had been going on for far too long. So yes, there are societal implications to people who develop long-standing mental illnesses, and I can say it now. I have a mental illness, and the fact that I did not spiral down any deeper into some of the sort of negative ill health effects and symptoms that accompanying PTSD is a miracle. But I think we do, jurors are plucked out of their day-to-day lives to perform a civic duty that they don't ask for. It's expected of them. It's part of the price we pay for citizenship within this great country. But we owe it to them to support them as part of that service.
Early detection is very crucial, I think, because once we're out that back door and we've done our civic duty, all other expenses are our expenses. The lost marriages, the broken relationships, that's all on us. When we have to go seek help, that's out of our pocket. The government is done with us. The province is done with us. Our civic duty is done. We walked out the back door, but we're the ones pulling into our driveway to what was a nice home, a peaceful home. I always explain jury duty as it's a scale. We all live our lives. We have a balance. We try and balance our life. We have our personal life and we have our careers. We try and balance that. And we always believe that if that's balanced, we have a good life. You throw jury duty in there, that definitely tips the scales. And we as individuals, we don't know how to get that balanced again. And that's where we need the government to help us with the early detection so that doesn't happen to not only us, but jurors in the future.
As I mentioned during my testimony, intimacy between my husband and I came to a dead stall. I was 35 years old at this time and extremely lucky that this was a very, very patient man, and he gave me all the time in the world. I think that without having the counseling, we would have never gotten back our life. I think our life as a family would have ended. There's only so long that somebody will wait. And what I had to watch, those girls being raped and tortured, it wasn't just watching the evidence, it was sitting in a box where I felt that I couldn't do anything to save them. And it was excruciating for me. And it took me a long time, and the counseling was tremendous help in helping me get back to my life and my family. And I'd like to say that today, I have been married 36 years to this man, and I am so grateful that he was there and so patient.
For me, I'm not special. I don't proclaim to be. I'm from a small town in the middle of nowhere. Why did I get the support? Because of where I worked. I just asked the question, why would Bobby in Alberta or Saskatchewan, Quebec, or Nova Scotia not get the same support that I was lucky enough to get and receive here in Ontario? So that's what I would look at, just equality across all the provinces, and put that out there. Thank you.
Thank you very much. Ms. Khalid, then Mr. Cooper, then Mr. Fraser. Ms. Khalid.
Thank you, Chair, and I really want to thank our witnesses today for your very compelling testimony. I have a question with respect to preemptory challenges. It's a way that councils on both sides can really pick and choose which jurors they want, and I'm wondering, do they have the tendency to pick jurors that can relate more to the issue? For example, Mr. Glue, you mentioned that you have a 2-year-old, and yet you sat there listening to evidence day after day for the murder of a 2-some-year-old. So I'm wondering, what is your viewpoint on these preemptory challenges that allows council to change and to play a little bit with who sits on jury, and how can we fix that if it needs to be fixed?
I'll just talk, if you don't mind. For myself, there was very little interaction with either the defense or the prosecutor. When I was there, they asked several questions about, had I been on social media, had I heard of the trial, was I aware of what had happened. There was no questions to my background, my marital status, how many children I had, anything like that. Whether they get that from a census or whatever, I don't know if they have that information, if it's available. I don't know what investigative process they have to go through. I know that when we first started out, there was 375 people in a room, and we all got a little ticket, and they, wheeled around the ball and pulled out, and I was the one who won the lottery that day and was on jury. Was asked 3 questions, and then I was a juror.
That's it. Unless anybody else has a comment on this.
I think the selection and challenge process that you're speaking of is often unique to the case in court at the time. So in the case that I ended up being on as a juror, our panel was selected within a week, if not even a few days. So it was a very quick selection process. The only question we were asked was whether we had a bias towards mental illness and mental health, ironically. Because at the time it was an NCR case, so not criminally responsible. So the defendant in that case was offering a defense of mental illness to absolve him of the crime. But I know Patrick can probably speak to challenges and the like with a lot of length.
I'm not going to really touch the subject of how they actually get the jurors and summon them. I think there's a study that needs to be done on that, whether it's census or how they get their information. But I will say that I probably had 1,400 jurors, potential jurors, go through, and I was picked as juror number 3. And I tell you, I sat there and I must have watched 1,200 individuals get up there, get their 3 questions. And because my case had 5 defendants in it, so the challenges were granted more, of course, as we know. But they know who they want. They have a good idea who they need, and they go through. And it takes a special person to fill what they're looking for. And they know who they're looking for. So after 1,200 people have gone by, I can even say after like 400, I could tell who was going up there and who was going to make the lies and who was not going. I could almost pick the challenges myself. So they know who they need and who they want. It takes a special individual to be a juror, and they know who they want.
All right. Thank you very much, Mr. Cooper.
Thank you to all the witnesses for your testimony. I know it's very, very difficult for each of you. And all of you talked about the fact that you did receive some help. In your case, Ms. Dancer, that was court-ordered and court-provided. In the rest of your cases, you had to do it on your own. Obviously, the case of you, Mr. Ferrant, you live with PTSD. Your life has changed. There's no question that for all of you, your lives have changed in the sense that you will always live with the memories and the horrors of what you endured and witnessed in those trials. We talked about Ontario with up to 8 counseling sessions. Manitoba, I understand, had a process, a debriefing session. All of you talked about going through help and getting help after, but I just would like to be interested in maybe fleshing out a little more what that involved for you. I understand that everyone's experience is different. Some people are not affected, some are impacted much more, but I would just be interested in understanding a little more about what it took, what you went through after the trial to see some semblance of life returning to normal.
It was an intervention for me, in essence. So I was, I knew there was something wrong with me. I was not alien to it, but I was again hoping it would go away. But as I got worse and worse and worse and worse, and my family became more and more concerned, particularly my wife and my sister. it took somebody to shake me and say, you need to do something about this. You need to seek help. There is something wrong with you, and it's okay. And you know, I basically broke down and explained that I just couldn't escape these images that I was seeing. I walking around, it was just omnipresent, bombarded by things that I just couldn't get out of my head. You know, walking down the street, on the subway, in a business meeting. I was no longer going out with friends or socializing. I would, life just got incredibly complicated. So, unfortunately, in my case, the first place I called was the courthouse to seek help, and of course those calls went unanswered because at the time. There was, there was court-appointed counseling, but it had to be issued by a judge. So I had to phone. You're almost repeating your story over and over again because every health professional you call, you're explaining yourself, saying, "Well, here's my story." And you're spending like 15 minutes on the phone with somebody trying to get access to explain your situation and get access to some sort of service, and then they say, actually, we can't help you. Or going to your in the end, I went to my GP who just sort of threw up her hands and said, well, we'll try and get you into contact with then it was CAMH, but the Center for Addiction and Mental Health. But that was a year-long waiting list. And then I was given a list of counselors, and again, I'm interviewing counselors. I'm calling them up and saying, okay, so this is what I went through. And I was baffled that I was even doing this. And again, at the end of the line, no, I really can't help you. I sort of deal with mood disorders, and I think you might have one, but it's not the mood disorder that I know of and can help you with. I'm not really trained in that. Let me give you the name of somebody. And then you're phoning them, and it just boggled my mind that I was doing this.
I'm usually a pretty strong individual. The first day of court, they played a 911 call with horrific screams of one of the victims in the background. From that moment on, it sort of rattled me. When court did end after 10 months, the overwhelming feeling of guilt and isolation that I put between my family and me was absolutely incredible. This case turned me very sensitive. I used to sort of make fun of my wife that would cry watching something on TV. I'd be the type, oh, that's just TV. Now I look over and I'm the one crying now. So it changed me. It made me very sensitive. Me seeking help, I didn't think I needed it the first day, nor the second day, nor the third. But after 10 long months of it, my new career broke me. And I knew I needed help. So I sought help. My job only gave me very limited amount. So to keep my family together, to keep my sanity together, I went and I pay out of pocket to see professional help. And really, that's not fair.
Again, as I mentioned, in my case, the counseling was mandated by the court due to Justice Lesage, who, after the trial, needed counseling himself, as did many of the court staff, the reporters sitting in the courtroom, pretty much everybody that was a part of that. It's been over 22 years. I still have residual effects. If your 85-year-old granny was standing on the side of the road waving me down to help her with her broken down car, I ain't stopping. I'm not stopping for anybody. I'm distrustful of most strangers. My family life is back to regular, but as a societal person, I'm highly distrustful of people.
For me, my mom passed away in 1999, and I was in a pretty dark place. After that, I sought grief counseling to go through and deal with the death of a parent. Coming out of the trial, I could feel myself going back into a kind of a dark place. I'm not trying to equate the two, but I could feel myself going there, and I was self-aware enough and had some coping strategies from the grief of the passing of my mom to kind of deal with that and know to reach out. And obviously my wife encouraged me to as well. I was very, very fortunate to find an amazing counselor right off the bat who listened to me, sympathized with me, gave me more coping strategies, and was just an amazing person. And to this day, I thank her all the time that I talk to her.
Thank you very much. Mr. Fraser?
Thanks. Scott, in your presentation, you talked about during the trial having a separate break room or separate parking, I think you'd mentioned. I was surprised there wouldn't be a separate break room for jurors, but I'm wondering what suggestions we could maybe take on as far as what happens actually during the trial to make sure that, I assume that the issue is if you have interaction with perhaps the victim's family or even the accused family or supporters, it could be very difficult to get through that and be able to do your job. So can you perhaps touch on some of the suggestions that could come from that observation? And then if anybody else has anything to add, that would be great.
Yes, sure. We were in a brand new courthouse in local municipality, and they had lots of areas where they had segregated the jury from basically the rest of the public and participants in the trial. The one area that there was, I wouldn't say interaction because everybody was very respectful about it, but when people were going out to have a smoke outside, there's no separate area for them to go. They literally were, across the courtyard or, trying to keep a distance. Nobody was listening in or anything like that. We weren't talking about it, but it was just that interaction. It seemed kind of strange to me. The fact that our parking lot, we were parking with defense lawyers and prosecutors and witnesses. They all have to get to the courthouse. They don't have to pay for their parking, except they all park in the same areas. So when we're designing those things, there may be that opportunity to look at those areas where you already have the jury segregated for certain things. Why not just go that one step further? The parking was the other thing, just how we got out of there. I think Patrick mentioned taking different ways home every night because he thought, maybe somebody was following. You don't know who's out there from the family. Don't know what reporters are around the corner, especially in a smaller municipality and the papers are there. You don't know who is who. So to have that separation would just make more sense and a lot easier to deal with.
Okay.
Yeah, thanks. That makes sense.
Imagine being a juror on an organized crime criminal trial where there are multiple defendants and multiple parties and multiple gangs involved in a highly brutal act, and you are driving your car to a small courthouse and you are parking your car next to witnesses from those organized criminal organizations, and they're parking next to you. And they're sitting there staring at you, and they're intimidating you as a juror because they know you're a juror in that case, and they're watching you walk into the courthouse, and they have your license plate, and they know the make of your car, and you're a juror sitting in your car, and you can't call anyone in the courthouse to say, I'm in my car, and I'm terrified. And I want to come into the courthouse, please, because no one in the courthouse is picking up the phone because it's 8:30 in the morning and there's nobody there. And you're sitting there and you're calling and you're calling and you're terrified. And there are bikers sitting on either side of your car. That's the story from a couple of jurors from different cases across the country. Court officials are parking down below in a secure parkade that is protected by a barrier and a guard. And these individuals have to sit there and wait for the coast to clear. Can you imagine waiting for the coast to clear and then going into the courthouse? And then months and years later, every time a Harley Davidson turns over, they're thinking that bike is coming for them. So we owe basic security to individuals in cases like that. And it's baffling that it's overlooked. Like something so simple can be so devastating to somebody.
Thank you.
You have one short question, Mr. Sekand?
Sure.
You said you had one short one, please, because we're almost done.
Okay. Tina, you were saying that there was only 2 occasions that the judge mandated counseling. Now, this is a complete hypothetical. If counseling was available, more readily available, do you think this is something that would happen in every case, a lot more often? Could you just give me your sense?
No, I don't think so. You know, not every case is as traumatic as the ones that we've sat on. And so that, you know, most people who sit on a jury for, you know, a robbery or something don't need any post-traumatic counseling after a trial. But in the cases where it is traumatic and there's very graphic evidence that people have to watch, I think it should be mandated that it is provided.
So I just wanted to clarify at the end. First of all, thank you so much. Your testimony was profoundly impactful, I think, on all of us and all Canadians that listened to it. I think we all tried to put ourselves in the shoes of a juror, and in a case like this, and it's hard to do so. I mean, to hear about the issues with intimacy, the issues with being overprotective suddenly of your kids because you just see your 2-year-old as that 2-year-old, or the issues that you had in terms of burying yourself at work because you're just not able to cope with what's happening. I think we all really were helped by what you said. And I just want to clarify, so what I heard, and I just want to make sure perhaps one of you can just tell me. So the things that I heard listed: education in advance about the obligations of a juror when you first walk into that courthouse, or maybe even the letter that's sent to invite you to report for jury service. Something better than a 1970s movie. During the course of the trial, a better separation of the jurors and the victims and their families, and the accused and their families. Something in certain circumstances, counseling during the trial, or at least making it very clear that that's available to you at the end of the jury day, or outside of service, with a court-appointed person who is privy to the issues and keeps confidentiality and doesn't seek to influence you as jurors. Ensuring that the various things that you have to do during the course of the trial are understood, meaning that I can totally put myself into your shoes where you're a juror and then at home, after you leave courthouse, you're going back to the office to do the 6 or 7 hours of work. It's like you were away in negotiations all day, but you come back and you have 300 emails that have still accumulated during the day. You have to finish the day, and then you have childcare, and then you have responsibilities at home that you're never getting to. So something to help with that in terms of either employers being obligated to give full pay in addition to allowing you to have your job back at the end of the trial, or alternatively, if we can't amend labor laws, to make sure that the pay and the support that we provide, such as daycare, is available to jurors. Number 4, a clear debrief at the end of a trial to talk to you not only about the experience and to get lessons learned from that jury, but also to advise you of all of the counseling and other services that will be available to you post-trial. And number 5, whether it's Ontario's 8 consulting sessions or counseling sessions, or something more, even more generous, a clear amount of counseling sessions available to each and every juror at the end of trial. Is that basically what you guys are suggesting?
I think that is a very, I think that's very, very accurate.
Okay, well, I appreciate that, and I appreciate all of your testimony again. And so I'm sure all the members of the committee would like to just come over and talk to you for a few minutes, but we just have a short session at the end to adopt our budget, so we go in camera. I'll give a 7 or 8 minute break, and then we'll just resume. Thank you very much, everyone.
Amen.